happy. Anyone know what today is? International Human Rights Day. Exactly. Why is it International Human Rights Day?
Because the UNIVERSIDAD was signed.
Yeah. Exactly. Today's the day that the Universal Declaration of Human Rights was signed. So happy Sunday and happy. It seems sort of contrary. I know that I have you here giving class on a Sunday, but yet it's Human Rights Day. No, it's quite.
No, because we are celebrating the day this way.
Exactly. Well, that's true. It does make, in that regard, it does. But it might be a violation of your human rights to keep you here on a Sunday. But hopefully it won't be too bad. Good. Everyone okay? Everyone have some biryani or whatever upstairs?
No, it was not meant for everyone.
It wasn't meant for but
Okay.
at my law school, they used to organize events. For example, like the Constitutional Society, they would bring food. And that would basically be my dinner. Even though I wasn't part of that society, I would still just walk through the room at the right time, put a little pasta on my plate, and no one ever said anything. Okay, good. So, let's see. We left off yesterday by talking about freedom of expression, which we'll continue on today. We'll continue talking about freedom of expression. How you doing? We'll do freedom of expression, and freedom of religion. And I don't know if we'll get too far past that. And then tomorrow, at the end, we'll go over what's going to be for tomorrow. I'll have you read some stuff, and then other stuff, I think, for the sake of time, I'll summarize. So that way we get through more or less everything by the end of the class. Any questions about anything about the final exam? We can leave a few minutes if you want at the end of tomorrow's class, 15-20 minutes. For general questions, for a little bit of review. I can also talk, if people want, just very briefly, 10 minutes, about how to get into the field of human rights.
About the examination, I
Yes.
would say. Are you going to test our memory or our common sense or our understanding of things?
A bit of everything. A bit of everything.
Don't test our memories.
But not exactly memory. I mean, it's not going to be...
Which year this...
No.
Weird question.
Nothing like that. No. No, I mean... I'll ask you, for example, which was the first country to sign the International Covenant? No, I'm not going to ask you. I'm kidding.
So are you thinking out the question?
That's not a real question. No.
So that's very tough.
And it's a stupid question. Anyway, no. It'll be more analytical. I may ask you, for example, things. I could ask you. In the European Convention on Human Rights, do you litigate it in the European Court of Human Rights or in the Court of Justice? In the European Court of Justice. That? Would people know where? Where? Yeah, European Court of Human Rights. That's the type of question that I could ask you. That's fair.
That's quite tough.
That's not so bad. That's not so bad. But that is maybe the most, I mean, at least knowing what the mechanisms are. Do you need to exhaust all your remedies in order to go to the European Court of Human Rights? Yes. For example, yeah.
The answer is yes?
Yes.
So you said it's not necessary. The it's not necessary.
European Court of Human Rights?
In European Court, okay.
Yeah.
But in the rest of the world, when you're talking about the universal scenario, you said it's not necessary.
No, but in the regional courts, you always have to. In the regional courts, you do. In the UN. Huh? In the African context. In the African context too. You have to exhaust all your resources.
Every regional court does it.
Yeah, every regional court requires you to. Otherwise, it would be the floodgates would be open to. So that, and then I could ask you, a hypothetical question. Imagine this happens, and this happens. Based on your understanding of jurisprudence in the United States, what would be the likely outcome? Okay, and that, I mean, again, I'm not going to go into tiny little details about the case. Yeah, it'll be it'll be a mix of things, but it's not going to be anything. It's not going to be anything that we haven't talked about. So even if it's in the reading, but I haven't talked about it, it won't be there. Okay, the reading will obviously it helps you and it reinforces it, but it's going to be I'm not going to take out little details. It's not an exam to trick you. No, it's just really to make sure you get the basic ideas of this class, the basic institutions, mechanisms. You know the elements of what is a human right, right? It's universal, it's non-discriminatory, and so on. I mean, those types of issues that I'll ask. But beyond that, for example, I won't ask you who the first person to sign the first country to sign that. Or maybe on your test I will, but on everyone else I won't. No, yeah. You'll be fine. Everyone will be fine. And if you're not fine, we'll do the course again next year. No, I'm just kidding. Okay, so any other questions about anything? Like I said, if you want tomorrow, we'll review. I'll bring in 2 or 3 questions. That way you can kind of see different formats. But they're all going to be multiple choice. And I'll be here if anyone has any questions or anything. You just raise your hand. And I can't give you answers, but I'll be here. Yeah.
Actually, I have a question that I asked you yesterday also, that how the cases will go in the US courts, that how will they go in federal court and state courts. Because some questions which are not provided in US Constitution, some matters which a right which is not provided in US Constitution,
Yeah.
and later on after the amendment also it is not added to the Constitution. So in that case, how will we will bifurcate that this case will go to federal court or this case will go to state court?
Now you really have to look at jurisprudence on the issue to see where, and you also have to look at rules of federal procedure to see whether or not.
Because if some right is not provided in the Constitution, so it cannot be a constitutional question. So you said that, no?
You're right. Although there are many rights that aren't specifically enumerated in the Constitution, but still are part of the Constitution, right? So that's what makes the U.S. Constitution. And I'm not an expert in all of constitutional questions, no, but basically the way it works in the United States is that a lot of the Constitution has been interpreted through common law, right? So there's lots of things, life, liberty, and property, that ultimately is very expansive, right? So educational questions could fall under there. Marriage falls under there. Abortion rights falls under there, right? Because they're liberty questions, no? So the way that the jurisprudence has been interpreted over the 200 plus years since the Constitution, or more than that, obviously, it allows for interpretation and reinterpretation of what falls into federal and what falls into state. Does that make sense? So it's not so black and white that it's in the Constitution or it's not in the Constitution. A lot of questions have been read to be. Also, there's also federal questions, right? So for example, there's the Civil Rights Act of 1965, right, where private employers can't discriminate based on race, they can't discriminate based on sex, religion, and so forth. So that, even though it doesn't specify it in the Constitution, there's a federal act that allows for federal jurisdiction over those questions. So, for instance, whether a university can accept more African Americans, right? Like reverse discrimination, no, is what they call it. Even though that may be in a university in the state of New York, nevertheless, because it falls under a federal rubric, no federal framework, it goes to federal legislation and it got into the Supreme Court. You see what I mean? So, and then there's other concepts like equality and due process. Those are extremely broad, but due process could be access to justice, right? There's right to effective remedy. Questions of, for instance, how long you should until you see a judge. Imagine in a state court, you get arrested and you don't see a judge until 72 hours. It's a violation of your right. It doesn't say it in the Constitution, but the jurisprudence has told us that that's what it is. So it's not so black and white. You really have to go through the jurisprudence and go through the history and look at the federal rules of procedure of the United States, and with that you get an answer.
So that should be on the basis of the collective morality, because when we see that US America is an individual focused society.
Yeah.
So if collective right has been violated, so that will go to the federal.
What federal rights though?
For example, there is a Dutch society. Their right got violated for example, for clean water, like some kind of right.
Clean water, it could be a state question too. A lot of these questions that I'm saying could also be in state court, right? It could be state or it could be federal. I'd have to see. If it's a right to water question.
Because if that water body is present in one state, so how that will be state question or a federal question?
Well, it would depend. I mean, I guess it would look at who controls the water, and it would also be how you frame it. I mean, does the right to water impact right to life? You can make it a constitutional question. You see what I mean? If you're in other words, if your argument is over a constitutional question, so just because it's water doesn't necessarily mean that it's federal. It doesn't necessarily mean that it's state. It depends on how you, as a lawyer, make the argument. So if you want to make the argument that this lack of water is just a violation of New York law, you can do that. But if you want to make an argument that this is a violation of U.S. Constitution law because there's a right to life, then you make it a federal question. You see what I mean? So it depends on you as a lawyer whether you're framing it in terms of the Constitution or you're framing it in terms of New York law.
So if this type of question comes in the question paper in this test, question comes in the question paper which we are going to give
On the test?
On the test.
It definitely won't.
It won't.
No, these are questions that are more U.S. procedural, constitutional questions, and you're not going to get anything like that.
Because if the question finds that whether the case will go in the state court or in the federal court,
I mean, the class.
This is the problem of having an examination. Our focus is now, we have lost the focus on understanding and we are focusing on what type of questions are coming. I'm focusing on that, he is focusing on that.
Yeah.
So you shouldn't have examinations.
That's not.
Honestly, I mean it.
It's not my decision.
Please
It's not my
don't take it
decision.
lightly. It actually happens. When we're focusing yesterday I was focusing on understanding and enjoying, and today I'm focusing on what kind of questions will come. He's also asking that. We're all thinking of that only.
I have no choice but to give you an exam now.
I mean, whatever.
you give multiple choice.
So I had one input in her question. Excuse me. Yeah. You asked about the water body or not. The question of territorial jurisdiction won't come.
Yeah, that's totally far from what we're talking
Jurisdiction
about.
won't come here.
Exactly.
that won't
It won't come. It won't
That
show.
was just an example.
Yeah.
If any water, not even a territorial matter, but if any matter which is related to collective right of some group, which is how will we differentiate? That is the question. See, this is which will go in federal court because we have a hierarchy. First, you have to go to the district court, then high court, then supreme court. But in some cases, like especially petitions or appeals, in that cases we can go to high courts and supreme court.
Yeah.
Courts.
So yeah,
There's
but
different-
these jurisdictional questions have nothing to do with the class, so they're not going to show up. So don't even worry about it. If you want, we can talk about it after, and I'll answer your questions. But there's nothing on jurisdiction. The most that I can ask you is this question of, if a case is based on the European Convention on Human Rights, is it a European Court of Human Rights or is it the EU Court of Justice, right? That's the most that you'll get. You're not going to get anything on U.S. specifics on procedure. These are what I'm going to ask you, just general questions to make sure you understand the exam. One thing I will say that's interesting about the U.S. is because the way the Constitution is phrased, it's in very broad terms, many things fall under it. So for example, when Obama, the question of health care, whether he can regulate health care, that came under the federal because it's interstate commerce. Under the Constitution, the federal government regulates interstate commerce. So whether they can create a federal marketplace of healthcare, interestingly, that's interstate commerce. So things are understood. Highways, because highways move, so if there's legislation about a highway, it would be federal because that's interstate commerce. It's where, things like that. So anyway, okay? All right, any other final questions? No. Okay, then let's get on to the material for today. Okay, freedom of expression is where we left off. So we talked about this idea of the European Convention, which is focused in terms of positive rights. As we say, really every constitution in the world almost has it in those terms. You have the right to this, but within certain limits. And then the First Amendment of the U.S. Constitution, which is framed far differently than probably most of us have seen, which is this idea of negative right? It limits the scope of government into our own personal liberty to express ourselves. Yeah. Now, if we go through the cases, we left off with the Brandenburg case. Yeah. Norwood. That's right. Norwood. That's what we have now. That's right. So, in the Norwood judgment, if we remember the Norwood judgment, that was the case with the Twin Towers that were falling, and the question was there, this type of hate speech, which clearly it offends there's a law against offensive speech in England. There's a law against any sort of pictures that could insult, that could cause a bad feeling in someone. And what the European Court of Human Rights says is, for us here in Europe, what we value more is not the individual right of this person to say it, but rather the collective right of all those of those who are offended. And what we said was that it differs considerably from the U.S. approach, where the U.S. approach is much more about my individual liberties to say what I want, which in turn, according to the U.S., creates a free marketplace of ideas, as some jurists called it. Free marketplace of ideas. I think it was former Judge Wendell Holmes. He refers to it, this idea of a marketplace, where society works best, and we could agree or disagree on this, when we exchange ideas. The European approach is that actually society doesn't work best when someone can say what they want, because we know the consequences of that, which was the Holocaust, right? So it's a much different conception. And if we look across Europe, we find laws that, from a U.S. perspective, are extremely problematic. In Spain, for example, which has had a long history of terrorism, there's a law which criminalizes the apology of terrorism. That is, I cannot say, for example, that the Basque terrorists were justified. That is a criminal offense. In Holland, for example, they don't permit the sale of Mein Kampf. People know Mein Kampf? That is Hitler's book, right? Hitler's book, right? That's prohibited. Anti-Semitic, anti-Semitism, and so on. The Sieg Heil a few years ago in Germany, a right-wing neo-Nazi got on the train and he gave a Sieg Heil, and he was arrested and charged. So again, laws are far stricter in there. Even things, for example, just to tell you how far the courts go in the United States, there was a case some years ago in California, a federal case, where a woman was driving her car and there was a police there with a radar. You know how they use radars? Do you have that here a lot? To see how fast you're going?
Speed guns.
Speed guns, yeah. And as she was going by, she went like this to the police officer. He pulled her over. He arrested her. He put her in jail. She went through a trial. Oh, not through a trial. She was released the next day, and she sued. She sued the court, and what the court said was, actually, that's within her freedom of expression. This is political speech, and they awarded her $200,000 for wrongful imprisonment. It makes you want to just drive around the U.S. doing that to police officers with the hope that someone will arrest you, so you can make $200,000. No, but just so that was political speech. So what we should take away, again, what we have to take away from this is just how far the U.S. courts go to find that something is political speech. And even when it isn't political speech and it's pure hate speech, the court has said that that itself is protected. I think it was Sandra Day O'Connor, the first woman to be on the U.S. Supreme Court, who said the bedrock principle of U.S. society, of U.S. democracy, is freedom of expression. And we cannot condemn, or we can condemn it, but not legally, hate speech, speech which makes us feel uncomfortable, speech which offends us. That if we want the right to say something, that implies a two-way street and the right to hear something as well. Okay? Now, if we advance a little bit, we have another case, which is the Pavlov. Actually, I want to just look at Peter versus Deutschland quickly. We're going to skip, for the sake of time, we're going to skip the Pavlov case. So in Peter versus Deutschland, we have an interesting concept that comes here. So this here, yeah, sorry, this here is not a question of hate speech. What we saw before was in the United States was hate speech, really. Here, this isn't a hate speech in the case of Peter versus Deutschland, but this was a case where, everyone know what PETA is? People for the Ethical Treatment of Animals. Do you have that here? Do you have a branch here?
Yes.
So, they created an ad campaign in Germany. Deutschland is German for Germany. They created an ad campaign where they compared the slaughter of animals to the slaughter of Jews in the Holocaust. Yeah? they were sued, and the lower courts ruled for the state, right? They ruled in favor of the state, saying that there were grounds to fine them for this behavior, that it goes against Article 1 of what's called German Basic Law, which is human dignity shall be inviolable. To respect and protect it should be the duty of all state authority. Every person shall have the right to express themselves, but within certain limits. And then, where is it? And then anyone who insults shall be punished with imprisonment for more than 1 year. And it also protects against, in any way, denigrating the honor of victims. Yeah. So this case goes, and this was never meant to be hate speech. This was meant to be an advertising campaign. Clearly, a strong advertising campaign. Now, if we look at, if we go here to this part here, notice something. So, in order for the court, in order for non-hate speech cases, in order for the state in Europe to demonstrate that the infringement was permissible, they have to satisfy a test. Yeah, and the test is this. Yeah, it has to be prescribed by law, meaning that whatever law they're basing their infringement on has to be prescribed by law. Everyone know what I mean by that? Yeah? Okay. The second thing, well, it doesn't say it as directly, but there has to be, what we can call a legitimate aim. It means there has to be an aim which is one of these. Right? Everyone understand that? So, health, morals, in this case, for the protection or rights of others, that would be the justification here. And then the European Court of Human Rights, in making a determination whether there is democratic necessity to do this, it gives every state what's called a margin of appreciation. Anyone know what that means? It's a term that's used within the European framework. Sometimes they call it the proportionality test. And what it means is that every state, considering the vast diversity that is Europe, right, 47 states within the Council of Europe, it gives every state a margin of appreciation, meaning it allows that state to argue in support of the violation based on that country's particularities, like its history, its culture, and other factors, right? So is it prescribed by law? Here it is, because it's in the German Basic Law. Is there a legitimate aim? The legitimate aim is again, for the protection or of the rights of others. Here, of those people, as they say here, who were victims of the Holocaust, right, or their descendants. And then 3, is this necessary in a democratic society? In other words, explain, based on the fact that you are Germany, why there is a democratic necessity. So, in the case, obviously, of Germany, the democratic necessity is its past, right? In the case of Spain, where, as I said, where there's been a long history, about 40 years of terrorism, even though it's now basically stopped. I don't know if anyone's familiar with Spain, but the northern part, called Basque Country, for many years was trying to break away, to have their own language, or basically independence movement, that was what it was. So about 1,000 people had died over the last half century in Spain. And so there is a law against violating, it's called apology for terrorism, or violating the honor of victims, right? And how is Spain able to do that, to limit free speech? Because of its margin of appreciation. So those 3 things always need to be met, right? Number 1, prescribed by law. Number 2, there's a legitimate aim. And number 3, it's within the democratic necessity of that country. Good? Any questions?
So what was held ultimately in Peter's?
Sorry?
What was the ultimate
of this case?
damage? Yeah.
They said that Germany was correct in applying the fine. It says, if you look at paragraph 49, the court considers that the facts of this case, and this is margin of appreciation, right, cannot be detached from the historical and social context in which the expression takes place. Yeah. It observes that a reference to the Holocaust must also be seen in the specific context of the German past, and respects the government's stance that they deem themselves under a special obligation towards the Jews living in Germany. Okay? So that is the conclusion of this. That is the decision of this article. What do people think about this idea that margin of appreciation is permitted? Should states be allowed? Does that defeat in some way the idea of universal human rights?
We in India don't believe that. We believe yes, this margin of appreciation thing is, the proportionality thing is very much...
Do you use that here?
Yeah, we agree with this.
In what sense? How?
Because we are having this, we are living in a system and we are apathetic that we have these reasonable restrictions put in place. We don't like people hurting us.
Yeah.
You know? So we don't hurt either, and we don't take hurt. You know, it's like a mutual thing. We don't just hurt people by putting on posters. Like, you know, if you are from Spain, you are not allowed in India. I won't put that here, only to assert my right of freedom of expression. Considering, because we have grown up in a culture, or we have that cultural background where we are practicing tolerance and respect simultaneously. Mm-hmm. So it's as much about tolerance as about respect, you know. So if my tolerance is more, I can definitely get stamped. But that also includes this right, or this part of it. The deal is like I have not to hurt.
Yeah.
So that's
But how does margin of appreciation come in there? I mean, in other words, do you, depending on the part of India, do you take into account cultural questions?
Yeah, those are there sometimes. Not that there is generally. So there is a class culture when we come to from one country, but of course there are certain specifications also. There are phrases and words which are maybe common here, maybe not very common in some other part of the state, and those are taken into consideration when it comes to this, like ultimately.
Yeah.
That is part of it.
Okay, interesting. Yeah. You want to?
No, in fact, the situation is quite the opposite in India. There is absolutely no tolerance, and it's not only for people from outside
That's
India,
generation gap.
it's also for like people of different religions and even not even religion, regions. Like some from North India going to like a Maharashtra, going to South India will be discriminated against, and there's a lot of regionalism. People from Northeast India are not accepted very easily into mainstream society.
The question was whether the practice that we are having about freedom of expression, whether that is good for us or not. It was not about how public.
Yeah, I get it, but so they like exactly. So that is.
Say again.
Strict regarding the freedom of expression, there is one RJ who have made a video, rap video regarding the one government association. And not the video and the rap is very liberal, kind of sarcasm. But she has been harassed, and the complaint also has been filed against.
Is she the radio host? Is that what you said?
Yes.
Radio jockey, RJ is radio jockey.
Okay. Well, here, for example, could you, let's say, make fun of your president or prime minister?
No, you actually, so you can critique the government, but then again depends on the. So what you were talking about yesterday, right?
Technically, you can.
That includes in the question of fair government. If you know that some of your ministers are publicly use so in that case, if you are putting a fair comment, so that will include in the fair comment. But in any other case, if you are blaming a government, if you are putting a bad comment about the government, so that will include in.
What about, for example, just let's say there's a lot of. There are questions about the relationship between Donald Trump and Putin. Have people heard about that?
Yeah.
So there have been a lot of shows on TV, someone dressing up like Donald Trump making love to Vladimir Putin. Could that, for example, would that be permissible here?
But again, it's
One person at a time.
One person who is have been punished right now for a rape charges, and he made a fun of that person, and at that time he's in jail because of making fun of that person who is now alleged of rape. That is Ram
But sir, it also depend on the government that is in power. So so right now, if you have a very right-wing government, or right now in this district you have a government who is very intolerant, then maybe you could be put in jail for a Facebook post. But if they are practicing legally, you can critique the government.
I guess the question is, what is, if you are, for example, put in prison, let's say, for, or at least charged for making fun of a government, what is the legal basis for it? I mean, in other words, here we have all these limitations.
So under sedition law, it's mentioned that if you're inciting violence or something, but then the law in paper and the law in action, that's very different.
But the misuse of law actually.
Sorry?
That's a misuse of law. Sedition law does not involve Facebook posts. But if the if the administrator wants to apply it in that sense of the term, that's a misuse of the law. The law doesn't say that. Supreme Court doesn't say that.
So they say, oh, it amounts to sedition. They put you in jail. Whereas it's not sedition. It does not incite violence.
So it is not
It's
necessary
just
that you will be convicted.
interpretation. It just depends on government to government, like Congress and BJP. Earlier we had Congress, now we have BJP.
Right.
Now there's lot of nationalism thing going on in the country.
Okay.
A small thing can incite violence and they'll put you in jail for sedition.
Interesting. I would say, I mean, one thing I think that's important to... Sorry?
The freedom of expression is guaranteed under 19.1, but 19.2 provides for an exception to that. Restrictions. Restrictions have been provided.
In India, we have a concept of reasonable man. Right? What a prudent man would think in that situation, that whether it is a violation or not.
Yeah.
So in that concept, according to that
But
concept,
what about what I said about Donald Trump and Putin making love together? I mean, a joke obviously, but could that be? So that's
sorry, the show is called the Make
okay. Yeah.
Political satire.
So what it sounds like here, from what you're saying, though, if I can just is that perhaps it's not so consistent, the application, no? Is that, and I think that's maybe how it differs in the United States to an extent, is precisely that the government tries to stay as neutral as possible, precisely for that reason, to not have inconsistencies, right? Because in Alabama, where they're more conservative, more evangelical,
You have to understand the way prosecution is done in India or in West Bengal.
Yeah.
Our police is controlled by the administration. It's like that, but there is certain amount of impartiality probably in your country which is not there. So what happens when a girl is, or when some Facebook post person making the Facebook post is arrested for sedition? Police is guided by the political inspiration or the leader's reaction. That is what incites this misuse of law.
Yeah.
Right? That is what the law says. The law is very much there in place. The law says what my friends, the younger ones are saying.
Okay.
But that is being misused because the whole prosecution process is guided by political consideration.
I understand.
Right.
Politicians
But
get
that doesn't stand ultimately. The court doesn't appeal that.
Right.
That is not what the court says.
Actually,
Right.
they're following the adversarial criminal justice system.
Yeah.
That's why the judge should not participate actively. So
Yeah.
that is the problem that
We are basically more focused on the procedures.
he cannot interpret the law.
Yeah.
That is the fact of it. The judge cannot interpret the law.
Courts in India are very much for.
Law is defined everything, and even the restriction is properly being defined. But the interpretation had been taken in a political way.
Yeah. Sure. I will say one thing that I think is interesting. I was mentioning this to someone yesterday, and I was going to tell you in a little bit. But as I said, I mean, as you can see from the jurisprudence in the United States, by and large, there is. I mean, again, there have been all sorts of issues, but by and large, there is a push towards neutrality, both in terms of police, but also in terms of the courts. I mean, the police won't arrest precisely because they know that they themselves, like in the case of the person who goes like that, they can obviously have trouble for wrongful imprisonment. But what I think in the United States, what we are seeing, and this I think is a grand hypocrisy, is those who preach human rights oftentimes, left-wing universities, for example, like Berkeley, California. Have people heard of University of Berkeley? What we've seen recently is an intolerance by the left towards the right. And this is where I think, even though we like to pride ourselves in the United States on strong principles of freedom of expression, recently I think, and I think this is a mistake, the university system has really pushed against the rise of the right wing. I think the case in point is Berkeley and, well, a few other universities where a number of right-wing speakers wanted to speak. They were invited legally. People like Ann Coulter, Miko, and something or else, Richard Spencer, people who are right-wing, who I myself don't agree with in the slightest of ways. They talk about a white ethno-state. They talk about building walls. I mean, it's part of Trump's. But it's more extreme, I think. But universities, public universities, have blocked them from speaking, and that, I think, has been a big problem. In fact, another thing that public universities have done, and they've started to create laws against it in 12 different states, are non-speech zones. That is, areas of the university, public university, where a private can do what they want, public universities where people cannot, for example, give out flyers. Let's create a white ethno-state. And that, obviously, for Americans, the university is where this discourse should be happening, right? At least, again, from an American perspective. And some states are legislating against that, saying, in this area here, and the courts aren't agreeing. They're saying that this is in violation. And many states are legislating against these idea of what are they called? Free speech zones, but zones that are free of speech. So even though, again, I come here and I talk about this importance of individual liberties and freedom of expression, at the same time, in recent years, we're seeing a bit of a pushback. And I'll just give you one anecdote. I was giving a talk at another university in Madrid 2 weeks ago, and a student asked me, she says to me, I'm a lesbian, she says, based on what you're telling me about free speech, do you believe that in this public square, not too far from here, a right-wing group can have a rally against homosexuals? And I said, yeah, of course they can have a rally. I mean, assuming they have a permit, everything is legal, there's no violence. And she says, well, that offends me that they're allowed to rally against gay rights. She goes, that's offensive to me. And I said, well, do you offend them? And she says, I don't offend them. And I said, well, what about, for example, do you ever kiss your girlfriend in public? She goes, of course we kiss in public. In the subway and here. I said, well, maybe that offends someone. She goes, no, it doesn't matter, though, because I'm the tolerant one. They're the intolerant. And I said, well, okay, so they can't speak. Anyway, she got angry and she left, actually, the talk. She goes, I can't listen to you anymore. And she left. And that was the end of it. But that is, I think, a certain, for me, something that's of concern that the left, which is something that I identify with, politically, nevertheless is creating sort of an intolerance towards the right. And that goes against the American principles, in my case. It may not go against European principles, it may not go against other countries' principles, but from an American point of view, if someone wants to argue against hate speech, against gay rights, well, they have just as much of a right, in my opinion, as does someone who wants to kiss on the street, a gay couple, right? So that is, I think, something that we're increasingly seeing amongst this generation. Actually, I think it's a generational thing, if I can be perfectly honest. And it's something that we're seeing, I think, increasingly in the United States amongst left-wing schools. Even when I was in university, which was up until about 2004, so you can date me like a fossil. I remember they wanted to bring a Palestinian poet. I went to a very left-wing university, right, as I said, right on the border of Vermont. And a Palestinian poet wanted to come, a very well-known poet, and he was blocked from speaking by the Jewish organization. And to me that just, it just reeked of hypocrisy. But that is something that kind of stays below the surface in the United States, and increasingly has come to light. But that is a way that speech is oftentimes controlled, but in a way that I think is against basic constitutional what's permissible within the Constitution. So again, we may not at the judicial level legislate as much as other countries on these questions or against these questions, but through more subtle means like university blocking, we tend to see a lot happening there. Okay, let's go on to the next case then. The case that I want to look at is Virginia v. Black. It's one of my favorite cases. So this is a case. Anyone want to tell me? Anyone read it? Sort of. Okay, then I'll tell you what's about. Crossburning. Yeah, this is a case about crossburning. Although you are wrong in calling it crossburning. That's how you know whether you're a Ku Klux Klan member or no. So I guess you're not. It is called. I'll show you a video. This is not. He says it. It's a cross lighting. right? Because it's illuminating the cross. It's not burning the cross. So apparently that's how, according to a video that I'll show you, that's how you know the difference between someone who's in the Ku Klux Klan or no. So we'll assume you're not. Okay, so this is a case where there is a Virginia statute which criminalizes cross-burning with an intent to intimidate, which is okay, right? I mean, you can't intimidate people, right? I mean, as I said, I can certainly express the fact that I don't support two homosexuals in kissing. I'm at, like what this girl said, for example. But what I can do is, as she's kissing, go up to her and start, you can't do that, you're just, intimidating her. If you keep doing that, I'm going to hit you. Those are fighting words, right? And we know that that's not permissible. So the problem here is that the statute says basically any time you burn a cross, it's instigation, right? It's intimidation. Everyone follow that? So it automatically reads into it. So this case goes to the Supreme Court, and the Supreme Court has to analyze whether or not there is in fact a violation, right? And hold on, let me just 1 second. Let me just get to what I wanted to point out. And actually, if we look at what it says here, it says, where is it? If there is a bedrock principle, this is my favorite line, underlying the First Amendment, it is that government may not prohibit the expression of an idea simply because society finds it offensive or disagreeable, right? Now, what has to happen here, though, is similar to the European Convention on Human Rights, where there is a test. In the United States, we also have a test that we apply in cases of non-hate speech. Everyone understand? And that is, we always have to ask the question, is this restriction that's being imposed on the speech content neutral or content based, right? And if we look at page 168, paragraph B, it says that the Supreme Court of Virginia, in this case, that even if it is constitutional to burn cross-burning in a content-neutral manner, the Virginia cross-burning statute is unconstitutional because it discriminates on the basis of content and viewpoint. That is, when we're looking at when we're looking at a case, we need to ask ourselves, content-based or content-neutral? Something that is content-based is where it seeks to regulate the expression of a viewpoint or regulate the discussion of a topic, right? Everyone understand that? So it's not content neutral. What would be content neutral, for example? I'll give you an example of what's content neutral, and then we'll talk about it a little more. Content neutral would be when there is for example, every 4 years we have a Democratic and a Republican convention. Yeah? Everyone know what I mean by that? Yeah? We have a convention where we nominate who's going to be the candidate, right? On the Democratic side and the Republican side, and then I think the Green Party probably has one too. But they have one. And what happens is, because it's a national security issue, they say that nobody can protest. This happened in New York a few years ago when they came to Madison Square Garden, which is a big, anyone heard of Madison Square Garden? It's a big sort of stadium in New York City. It's actually, you know who spoke there? He had a huge, Modi. Yeah, he had a huge he was like the rock star of New York, is what they called him that day. Yeah. Really, I mean, it was amazing. But he filled up. 30,000 people came to see him. It was amazing. No, but so they said, look, nobody can nobody can protest of any in support or against within 2 blocks of the stadium. Everyone understand that? So that would be content neutral, right? Because we're not regulating what type of, is it people in support or people against? What it's saying is because of national security, if Modi comes, for example, right, the Secret Service, the security agency that protects foreign leaders, or our president too, they create a security perimeter. So I can't go near if I'm supporting Modi, and you can't go near if you're not supporting Modi. Everyone understand that? So they're not discriminating based on the viewpoint, right? But what they're doing is, it's what we call a time, place, and manner restriction. Right? Everyone understand that? So what they're doing is they're regulating the time, the place, and the manner of your speech. Is that clear? Okay, so let's then start with content-based, which is what this case is, right? This is a case where what they were targeting was not that you can't do anything, you can't put anything on fire, you can't. No, they were targeting clearly the expression, right? Because it specifically says cross-burning. Yeah, cross-burning is freedom of expression because it's symbolic expression, right? We know that it's not only oral expression, but it's also symbolic expression. If I do a dance, that's still expression, right? Okay, so when we have a question that is content-based, the test that we use is that the government, in order to infringe, has to demonstrate a few things. One, that it is a compelling government interest, that there's some compelling government interest. Very similar to this idea that there's a legitimate aim. But notice it's not enumerated in the US Constitution. Everyone see that difference? So a compelling interest. It could be national security. It could be, for example, yelling fire in a movie theater, right? The compelling government interest is you don't want everyone running out. Is that clear? So that would be a compelling government interest, narrowly tailored, right? So it has to be as narrow as possible. Yeah? And it has to be the least restrictive approach necessary. Does that understand? In other words, you can't, what they're saying there is you cannot burden more free speech than is necessary. So this is the highest level, and this will come up again when we do freedom of religion. This is the highest level test. When something is targeted because of its content, when you're restricting, for example, the rights of Muslims, for example, right, to wear, for example, headscarves, for example, right? That is content-based, right? As opposed to if you say no religion can wear anything on their bodies. Well, then it's content-based, content-neutral, right? Everyone see that difference? So the government, the courts have said that if you're going to target viewpoint, right, which has the highest level of protection, right, because it's personal view. It's not something general, but it's personal view. You have to be able to overcome what's called strict scrutiny. And that's the name of this test here. It's called strict scrutiny. It's the highest level test that the court affords, that the government has to meet in order to be able to overcome any sort of restriction or infringement. Yeah? Is that clear? Okay. Sometimes, and we'll see this in a case when we do freedom of religion, sometimes it's not that clear. Let me give you an example, actually. I think I may have, did I say this? What if I give you this case? Let's say, for example, the government of New York City says that nobody, and this is religion or expression, right? It's the same. We treat them similarly. Nobody can pray on the sidewalk. Yeah. Is that content neutral?
Yes.
It sounds it, right? Because the law doesn't specifically say who. But in New York City, who prays on the sidewalk? There's only one group, mainly, which are Muslims, right? And particularly we see it in Manhattan, for example, or oftentimes many of the taxi drivers are Muslims, and we see them oftentimes on their breaks, praying on the street. The courts have said that is perfectly acceptable, but that is a way that oftentimes when it looks like it's content neutral, it's actually content-based, right? So you always have to ask that question. We'll see. We'll look at an interesting case in a little bit. So what I want to do is, if I can get this video on, I want to see how this case gets analyzed, or how this case. Let's see if we can get this on. So this is a video. It's an interview with. This is I don't know if it'll work, but this is an interview with the lawyer for the who defends Black, right? Which is the Ku Klux Klan member. And if we can get it working, it's a fantastic video. Can you hear?
Member of the American Civil Liberties Union. knew from personal experience the importance of having a good lawyer.
I went to an historical black college for undergrad, and about 1969, 1970.
But it doesn't work out.
Was a leader of the Ku Klux Klan. But Baugh, an active member of the American Civil Liberties Union, knew from personal experience the importance of having a good lawyer.
I went to an historical black college for undergrad, and about 1969, 1970, Virginia decided that it wasn't going to meet its immigration guidelines for its colleges. So what it decided to do was to take some of the black schools and break them up and move them to white schools. And we said, no, you don't. So there were a series of demonstrations, and I ended up getting expelled. And while sitting in court, watching my ACLU lawyers defend me, I thought, this looks like something I ought to be doing. So I decided to go to law school my senior year.
After graduating from law school, Baugh started practicing criminal law. He was willing to take controversial cases to protect what he thought were important principles.
I remember once I got cited for contempt, one of many times I got cited for contempt, and my wife said, you know, we better have a little chat about this because the girls are going to bed, it's going to be in the paper tomorrow. My wife told the children, she said, you're going to see something in the paper tomorrow. Now, if you were walking down the street and you saw a dragon, what would you do? And they said, oh, I'd run, or I'd hide, or I'd do this. Yes, you would. But there are some people in this world who live to fight dragons. And when they see a dragon, they grab a sword and they go after it. Your father kills dragons.
Baugh is an active member of the ACLU in Virginia. He recalls his first involvement with Barry Black, a Ku Klux Klan leader from Pennsylvania, who'd been arrested in Carroll County, Virginia.
I got an email that a Klansman in the western part of the state had been arrested for crossburning. It is illegal to burn a cross with intent to intimidate. And any time you burn a cross, there's a presumption that there is an intent to intimidate. Kind of makes it easy to nail it. So I read this statute and I went, how in the name of all that's good and holy can that pass? What constitutional buster? So I called and said, you know, any somebody to take this case, I'll take it. A lot of people say, well, why would you defend a Klansman? It's a no-brainer. I understand that the Constitution is a set of principles, and if you're going to protect my right to say what I want to say, I have to defend that guy. It's easy to defend a friend, but when an enemy is having the principles you believe in violated, that's a chance to do the right thing.
Rod Smola, a law professor specializing in constitutional law, also volunteered to work on the case.
Once we decided to take it, of course, the question on the table, sitting around thinking about it, was, will this person, Barry Black, head of the Ku Klux Klan, accept as his legal team a liberal white lawyer, law professor, and a well-known African-American lawyer? I actually said, you know, we'd probably better let him know, David, that you're Black. But he didn't have any problem with it. He said, sure, fine, I appreciate your representation, and we took it from there.
The case had already generated lots of publicity. Once Baugh took the case, there was a news story. An African-American lawyer was representing a Klansman.
I was being interviewed, and they said, well, you know, what's it like representing someone who wouldn't invite you to their house for a meal? I've never been to a client's house for a meal. I've never been to my doctor's house for a meal. What's a professional relationship? People assume that when you undertake the defense of someone in a criminal case, that you endorse or condone the behavior or allegations against your client. If Mr. Black had been in a horrible accident being driven back to Pennsylvania and was taken to a hospital in this state, his life could have been saved by a black doctor, a Pakistani doctor, a Jewish doctor. No one would say anything about it. No one would care. But because the lawyer comes in, they go, aha, if you're undertaking a case and you feel a need to distance yourself from your client, that's conflict. Well, I didn't think anyone was going to accuse me of being a closet Klansman. So I thought I was the perfect person for the case.
Not that Baugh didn't have second thoughts.
When you do things because of principle or professionalism, and that's what it is, every once in a while you stop and think, wait a minute, what the hell was I thinking? Especially when this press started coming in. And I called my dad within 24 hours because he's not a lawyer, he's a fighter pilot, retired colonel. And I said, I just show himself to be a real nice guy and all that sort of stuff. And I explained to him, I said, no, wait. You have the right to be a bigot. We don't have to be friends. We don't have to have a kumbaya moment. I'm not trying to convert you. You have a right to say that, and my job is to protect you.
Baugh describes what had happened leading up to Black's arrest.
The allegation was that the Klansmen came down from Pennsylvania, met with the Klansmen here, and they decided to have a rally. They rented a site where they were going to have their rally, and the owner of the property was there. A little old lady was sitting up on the porch watching them, and they served hot dogs and hamburgers and railed on about, streets running red with blood and all this sort of stuff. And at the conclusion, they put their outfits on and they erect their Porto cross, which was like a 30-foot metal cross wrapped with rags. And they, I was going to say burned it. I have learned that you want to know if someone's a Klansman, ask them about that process, and they'll say, no, it's a cross lighting. Burning is about destruction, but lighting is illumination. That's when you know you're talking to a Klansman.
As an initial step, Baugh needed to develop a strategy for the case.
When looking at a criminal case, the first defense is the acts did not occur. The next one is, if they did occur, there's an explanation. The third one is, the acts occurred, there is no legal explanation, such as an affirmative defense. Therefore, I have to whack the statute. Because I couldn't say he didn't burn a cross, and I couldn't very well say that he hadn't violated the statute, the way the statute was written with the presumption thrown in there. So the only challenge was to challenge the statute.
Baugh's challenge to the statute was based on freedom of speech under the First Amendment.
No one in a free society has the right to walk around feeling comfortable or not intimidated or to feel warm and huggy and fuzzy. In a country like ours, you have the right to say what you want to say. Well, the corresponding responsibility is you have to listen to crap that you don't want to hear. Mr. Black had the right to stand in the middle of the field and say, I hate all African Americans, or I hate Asians. He can say that. No one would say anything about it. He can hold up a sign. I hate all African Americans, I hate all Jews. That should be protected. Well, the question is, can he symbolically make the same statement? And the answer is yes. One of the scary things about a democracy is that it's dependent upon an educated and intelligent populace in order to succeed. Which means every idea needs to be discussed. Every idea needs to be debated. So we can decide whether or not it's an idea we want to keep or an idea we want to chuck.
Baugh intentionally stayed away from presenting detailed history of the Klan or its rituals.
I'm sure there are Klansmen who say, oh yeah, it can be defended. It can be explained that this isn't a cross burning, it's an illumination, and we're not.
Okay, we saw the majority. It's interesting, no? I think it's one of my favorite videos to show, and it really captures in many ways the spirit of it. Okay. So, essentially what we get here is a question of, what is the compelling government interest here on the part of the government in prohibiting it? And they argue, well, it's intimidation every time they do it, it's racist and so on. Although being racist is not in itself, it's more this idea that it's intimidating, right? It's harassing. Okay, that is an interest. I think that is fair. I mean, we can't we can't incite violence. We can't do it if it's a fighting word. If it's harassment, fine. But is it narrowly tailored to achieve that interest and the least restrictive means possible? And that's the question, right? Because the law basically says, if you look at it, that any cross burning is an intent to intimidate, right? And that's where we get a compelling reason. Fine, we don't want to intimidate, but it's not the least restrictive means possible, right? Because what you could say, how would you rephrase it to meet the strict scrutiny standard?
There shouldn't be any presumption, only if it actually happens.
Exactly. There can't be a presumption. So everybody has a right to erect and burn a cross. However, if it is done with the intent to intimidate, then it is, then it can be criminalized, right? Everyone see that difference? So the automatic presumption, right, which is what you're saying, is the problem here, because it's not the least restrictive means possible. What if, for example, they took that cross, imagine right here lives a black family, and in front of their house, they put it there. Would that be intent to intimidate? Yeah, that we could probably read in that there's an intent. What if, though, it's people, there are black people who live in this neighborhood, and we decide we want to erect a cross? The question then is, is there automatically an intent to discriminate? And what the government, the Supreme Court, says here is, it's too broad, right? And if we look at the jurisprudence here, let's get to the, I'll read you one. So this is the opinion on page 182. I conclude that the statute under which all three of the respondents were prosecuted violates the First Amendment, since the statute's content-based distinction was invalid at the time of the charged activities, regardless of whether the prima facie evidence provision was given any effect in the respondent's case. In my view, anyway, so yeah, I mean, basically he says that there's been a content-based discrimination. They go through, and you can read this on your own, they go through, again, this idea of speech being the bedrock, and if you want to limit it, well, then you have to meet the strict scrutiny standard. Yeah, is that clear? Now, as I said, what about a case, for example, where, this was a case that happened some years ago, where there's an abortion clinic in New York, and what they say is that nobody is allowed, the police said nobody can protest within 30 feet of it. This 30, or I forget the exact number, but this 30-foot radius is off limits to anyone but those who work at the clinic and those who use the clinic. Okay, so in that case, would that be content-based or content-neutral? Content-neutral is what the court said there, right? So here the question is it narrowly tailored to further an important interest, and must do so by means that are substantially related to that interest and permit alternate channels? So what was happening here? As women were coming out of the clinic, people were going to the clinic, people were going up to them. Don't do this, why did you do it? You know, you've killed your child, you know, all sorts of things. So they were blocking traffic too in the streets. So the case went, it's called Schenck versus New York, or Eastern New York, I forget the exact name. I can look it up, but it's Schenck. If you type in Schenck abortion case. And the case went, and so the question was, can they be limited here? Can they infringe on these individuals' rights? And what the court said here was they said two things. They said, first of all, the floating buffer zone, right? That is, I can't, if she's walking to her car, what the police said at the time, or the law said was, I can't follow her. Everyone know what I mean by that? I can't talk to her. As she's going into the clinic, I can't say, don't do this, don't do this, don't do this. And then it also says, I can't be within a certain area. So they said two things. Number one, the floating buffer the floating buffer limit was too restrictive, right? They said that it must be narrowly tailored to further an important interest. Well, they wanted, what's the important interest there? Yeah, so...
Women were being intimidated, like they were being...
Yeah, that's what they said. That's what they said. But here what they say is that, fine, that maybe we don't want people to be intimidated, but that goes too far against freedom of expression, is what they say there, right? That goes against, that in other words, that weighing the interest, right, must be narrowly tailored. And they say that's not narrowly tailored enough, right? I mean, it's not sufficient. It's just that I can't say anything to them. Now, what I can't do is curse at them, maybe say, you baby killer. Well, maybe that I can't do. But what the law says is I can't do anything to them, right? I can't lobby them. I can't say, look, why? Think about it again. I can't do it. So the government says the court says the floating buffer zones are not narrow enough, right? That those are a violation of those individuals' human rights. But they said that the radius, or certain parts of the radius, were permissible. Why? Because people were using that to block traffic. into the clinic, right? They were blocking the door, they were blocking the driveway, and there they said, okay, keeping people from this intersection here, that is narrowly tailored enough, and it furthers it's substantially related to the objective, right? Substantially related to the interest. The interest there was not to limit speech, but the interest there was you need traffic to flow, right? I mean, you can't have people blocking traffic. You can't have people saying, no, don't come into the clinic, and preventing them from coming into the clinic because they have a right to come into the clinic. Everyone see that difference? So the floating buffer zone, they say, no, that's not narrow enough because even though we understand what you're trying to protect, saying that, I can't talk to you, I can't follow you to your car, they say that goes too far. I have a right, as you go to your car, to tell you my opinion on abortion. That's political speech, and that is fully protected, right? Again, they could say no fighting words, no intimidation. That would be acceptable. But the fact that I can't lobby you as you're walking to your car, the court says impermissible, okay? That it's not narrowly tailored enough. But in the other case, if this is the door to the clinic and I'm there, no, don't do this, or I stand in the street so no cars can come, well, then that is, again, it's narrowly tailored enough because, again, the aim that I'm trying to get to is allowing for traffic flow and people movement. Okay? Everyone see that? So those are the two ways in which we analyze questions of speech. We always need to ask ourselves, again, assuming it's not hate speech. I mean, hate speech is just generally treated as hate speech. Fighting words are just treated as is there an imminent likelihood? What is it? Imminent. I always confuse myself. Imminent lawless action. Is there gonna? If it's imminent lawlessness, we don't need to use this test, right? Or generally speaking. But for all other types of speech, we're always going to ask ourselves: is it content-based or is it content-neutral? And we have to dig oftentimes below the surface to make this distinction. Now, the question that I ask is, how does this differ from the European approach? And what I think differs is a few things, but one in particular is that the European approach doesn't care whether it's content-based or content-neutral, right? They apply the same level of analysis, which is this legitimate aim test. Everyone understand that? The second thing is that the U.S. approach doesn't raise the question of proportionality or margin of appreciation, right? At least not as explicitly as they do in the European test. Just give me 1 second. The third way I think also is that when we're dealing with content-based restrictions, and content neutral as well, the court in Europe doesn't really ask whether it is the least restrictive means possible. Everyone understand that? So what they require here in the United States is they sort of, if you can think of it, they kind of push you to the limit, right? Basically saying, okay, you can restrict it, but there can be no alternative, right? This has to be the only way in which you can restrict speech. Everyone see that difference? Whereas in the case of Europe, there may be alternatives for how we can restrict speech, but they're not so concerned with it. They're more concerned with the idea that once it begins to impede or infringe on the rights of the collective, that's enough for them to stop that speech. Whereas in the United States, again, it's this individual liberty, and the only way we can impede on, infringe on it, is if there's no other way for the government to meet a compelling reason. Everyone see that difference? Yeah? Good. Question.
The question was, you said that in the US approach we generally do not look into the question of proportionality.
Yeah.
But isn't the test regarding whether it's a least restrictive measure corresponding to a test of proportionality?
Okay, in that respect, let me rephrase. I should say more this sort of idea of margin of appreciation taking into account the culture is what I'm referring to there. You see what I mean? So yeah, you can say least restrictive, in that sense you're right, is sort of a proportionality question. It's relative, right? But what I'm referring to more is this idea that I say, well, you coming from Alabama, what's offensive to you as an evangelical Christian, well, we're going to take that into account. Do you see that difference? So they don't take into account, a region or a state's or a religion's cultural background. So for example, as I said, I could say, we have a large Jewish population in the United States. I can certainly say, I could go, for example, to Queens, where there's a very, very large Indian population, right? Everyone in Queens in New York City, could I go there and make hateful comments about Indians? The answer is yeah, I could. And what they wouldn't take into account the fact that I did it where there is a large Indian population. You see that difference? Whereas the European court would. I mean, again, they take it into account. Maybe not so much that one they take into account if there is a large population of Indians in Spain. Well, they would take that into account. Whereas in the U.S. it would be a neutral playing field. Is there another? Yeah.
So I have another question. If the restriction is content neutral, does it mean that the restriction is valid, or can it be invalid even if it's content neutral?
It can still be invalid. Because remember, the case that I just told you where they invalidated one and they upheld the other. Do you see what I mean? So they invalidated the content one, the content neutral one, where no one can follow these women to their car. But the other one, which was nobody can be in the street, they allowed. Okay? So yeah, the only thing is, the test is a little lower. When it's content neutral, actually I didn't say this, but we call it intermediate scrutiny. Sorry, I should have said that. It's intermediate scrutiny. Okay? So it's a lower level. If we compare it, here it has to be narrowly tailored to further an important interest, where here it has to be a compelling interest. Everyone see that difference? Again, it's semantics, no, but there's that difference there. Compelling versus important.
Strict scrutiny and the intermediate scrutiny are the same thing.
Two different levels. Intermediate scrutiny is when it's a viewpoint regulation, it's a higher standard. Intermediate scrutiny is when it's time, place, and manner, that we're not regulating what you say, but where you say it, then they allow for a lower standard. And that, I think, is for obvious reasons, that when you're going to target expression, the content of someone's expression, you really have to have the most compelling reason possible, right? Whereas if what you're trying to do is just control where they say it, because it could block traffic, for example, well, in that case, the court allows for an intermediate level of scrutiny. Everyone see that difference? So blocking traffic, for example, that could be, right? We're not going to give you a permit to march down Fifth Avenue on a Friday night at 7 p.m. during rush hour traffic, because again, it doesn't have to be a compelling interest, it could be an important interest, right? And that what is the important interest there? Blocking traffic. Imagine right here, this street here, when we come out, there's all that traffic. Imagine all of us say we want to get a permit to have a parade down that street, in honor of Human Rights Day. The government there doesn't need to have a compelling reason. It has to have an important reason, right? And that important reason is the fact that if you do it at 6 p.m. on this main street here, that would be a disaster for Calcutta. No? Everyone follow that? Yeah. Okay. Good.
On one with the content-based restriction.
Sorry?
On with this one. In UK, how the restrictions are supposed to be made a statement of legitimate reasons.
In UK?
Yes.
So UK, or we should say the European test, follows that idea that it has to be prescribed by law. It has to be a legitimate aim. Doesn't necessarily need to be the most compelling, right? It has to be a legitimate aim. And it has to be within the margin of appreciation. There has to be a democratic necessity, taking into account the context of that country. Everyone follow that? So we could say that in Europe, there's a lower standard. Okay? Everyone?
When we connected to the Virginia case, so that would be content neutral.
No, it was content based.
Content based.
Yeah.
But because we see that in United States, that is individual point, individual freedom, that we are like concluding some statement about somebody.
Right.
But and also that group has the same right. But so how can this be content-based?
The Virginia case?
Yes.
Because they were targeting the burning of a cross, is what they were doing, right? Other things, I could burn a piece of trash, right? But here they were specifically burdening the right to burn that cross.
So when we see that they also like give statements about it, just killing the black people or some, they are also targeting the same audience, the one group.
The Ku Klux Klan.
So that is also, it can be content based.
It's content based. Because what they're not saying is nobody can burn anything. They're not saying that, right? What they're saying is you can't burn a cross. You see what I mean?
So there's a difference of statement and action.
Right. So in other words, if the law said there's no burning of anything, that would be content neutral. You see what I mean? But the law specifically targeted the cross burning. So it's it's targeting the content. Does everyone see that difference, or not so much? Yeah. You see, if all it said was on public land you cannot burn anything, well, presumably on its face at least, that would be content neutral because it's not saying what. But if the law says you cannot burn a cross, then it's content based because they're targeting the content. They're targeting what they're doing and not just a general act. Okay? Is that clear? But what's interesting about these questions is the way that they could get arrested for it. They couldn't get arrested for it based on the burning of the cross. They could get arrested for just causing a fire in public. And that's oftentimes. So for example, you're allowed to burn a flag. Are you allowed to burn the Indian flag? Okay, in the US you're allowed to burn the flag. But you could get arrested if you do it in public because it's obviously it's a fire hazard to burn things in public. Everyone follow that? So that's how you oftentimes that's how you oftentimes get it. You know, instead of it's oftentimes, I'm trying to think, but they do similar things with firearms. What is the I forget again. But anyway, it's a side way of getting you. So yeah, then they'll do that. For instance, if I burn a picture on the streets of New York City of Donald Trump, they can't get me for freedom of expression. I'm protected. But if I do it obviously in the middle of Manhattan and I don't have a permit to create a fire, then they can burn me. There's some New York municipal law that would obviously they'd be able to arrest me on for causing a fire or causing a public danger. So that's oftentimes how they do it. But it carries, well, it could carry a lesser sentence. No, well, everyone clear on that? Okay. The last thing I want to do, because then I want to move on to freedom of religion. Once we finish, I'm going to advance a little bit. But someone yesterday brought up the case of defamation, and I just want to very briefly talk about the issue of in the New York Times versus Sullivan case. Yeah.
What's the page number?
204. Oh, thank you. So this is a case where a statement is made. I'll just quickly read it out. Where a guy named Sullivan is suing the New York Times because they make a defamatory statement against a local police force. And he says that as I think he's the commissioner, that he was commissioner of public affairs and that he has the duties of supervising the police, that defames him. Everyone understand that? Right? So it has to do with this question of defamation, no? And this idea of, well, what is defamation? Now, anyone remember, so when we talk about defamation, what needs to be proven here? What generally needs to be proven?
That the statement made was false.
That it was false?
And it was made in bad faith.
Okay. Sorry?
Adversely affected the reputation of the person.
And it had, exactly, and it adversely affected. Here, and I don't know, well, I'd like to know whether this was the same. What they say here is that when we're dealing with a public person, yeah, there's another factor, which that there has to be malice.
Actual malice.
Do you have that here?
Actual malice.
Actual malice, yeah. So the standard's the same.
Yeah, that's what they said, that you need to actually prove that there was actual malice.
Well, are you talking about here or in the Indian case?
No, in the
yeah,
in this
yeah,
case.
exactly. Yeah. Exactly. There has to be actual.
Same in India also. The standards are the same.
That's the same. Okay, well that's not so interesting. Yeah, exactly. It can be actual malice, or what else could it be? Reckless disregard. Right? So what they basically tell us here is that, but does actual malice, is that when you're talking about anyone, or when you're talking only about a public figure?
Public person.
Okay, but what if you're not talking about a public person? Anyone?
No, defamation is an offense even if it's against me. I mean, it doesn't have to be a public figure necessarily. In Indian Penal Code, defamation is a recognized, codified offense.
Yeah, but there's two different, in the US at least, there's defamation and then there's defamation of a public figure. And what this tells us, sorry? But do you differentiate between defamation and defamation of a public figure?
No.
Okay.
In India there is none, no?
That's the difference. So in the United States, when we're talking about defamation of a non-public figure, then we don't need to prove actual malice. When we're talking about defamation of a public figure, it could be, for example, the commissioner here of public security or public affairs. In that case, we have to prove actual malice or reckless disregard. Is that clear? Just to sort of, anyone not clear on that? I just wanted to tell you that. Just again, yeah.
What's the standard of understanding the public?
Yeah, it's a good question. There's different types of public figures. No, there is, for example, the person who wins the lottery is a public figure. Someone who has in some way either made it into a newspaper, for example, has gotten some bit of publicity, that qualifies as a public figure, basically. I'd have to look, actually, it's a good question. I'll double check to see if I can get a more exact definition. But someone that has, for whatever reason, really, I mean, it could be winning the lottery, or it could be because you are Karina Kapoor, right? There's not exactly a defined threshold, no. I mean, it's really for the court. The court has to make that decision whether or not it is a public figure. And actually, I don't think here, let me just double check. I don't think it's specifically, I'll double check. I may be mistaken here. There's not.
Maybe it is depending upon how much segment of public is there to that.
Yeah, it is. I just want to, let me just see. It's that time. I'll double check for you, and I'll see if there's one standard, actually. Now that I'm thinking about it, they may not have mentioned it here, but anyway, I'll check. But anyway, someone who has gotten some level of publicity, generally a public figure. Yeah, some sort of recognition, generally, in the newspapers, basically in the public arena, right? It could be on a very local level, for example, in someone who in, let's say, Haskell's Village, no? You know Haskell's Village? Someone who in the local newspaper becomes famous becomes known because they open up a bar. I mean, then at least in the U.S. that would be a public figure at that point, because they're in the newspaper, they may be on TV, they were interviewed. Someone who wins the lottery, for example, is a public figure. So all of that falls within the realm. So it's someone who has gained some level of publicity. It doesn't necessarily need to be notoriety or fame. It doesn't create the level of fame. There's a difference there, right? It just has to be someone who is is in the public.
So what happens to the person who's defaming the other person? It's on a personal, like the definition is on a personal basis, and it does not involve the question of the other person being a public figure or not. So how does this question come?
So when we're talking about someone who isn't a public figure, then what you need to prove is that a statement was made that wasn't true and it caused some sort of harm. When we talk about a public figure, then they add that it, not just that it caused harm, but that it created, that it was done with malice. Everyone see that difference? Yeah, is everyone clear on that? That it causes malice. And if we just look, let me just want to see, well, do you want to, is the time?
15 minutes break?
Yeah. Just, let me just, hold on, there's just one thing that I wanted to... Here, and this here gets us one of the reasons they say the erroneous statement is inevitable in free debate, and that it must be protected if the freedom of expression are to have the breathing space they need. So the malice, the part about malice, I think forms an essential part of this idea of encouraging free debate. Because what they say is, when we're talking about public figures, when we're talking about people who have been in the news, inevitably, there's going to be misstatements. There's going to be misrepresentations, and there's going to be lies. And the moment that we suddenly have to start, oh, I shouldn't have said this, maybe I didn't say that, I said this about Donald Trump, but it may not be true, I said this about Ashwiri Rai, or, you know, or whoever, or Bakban, what's her husband's name? Not Bakban, no? You know, again, the moment that we do that, or, you know, what if, for example, someone wins the lottery, and I want to say, oh, this person, you know, they did so and so and so. The idea here is that it allows for that free debate. Again, this idea of that individual right and that necessity, as we see in that video there, of allowing society to debate its ideas. I think, as someone pointed out yesterday, maybe too, of not infantilizing the society. Oh, don't say this. Oh, this is a lie. You need to check before you say that. Society. We would prefer to run society in the United States as more of a free market. If there are lies, society will push out those lies. Society will get rid of those lies, right? But the moment that we have to start watching everything we say, restraining ourselves, that's the moment that free debate becomes limited, right? So that is why they create this sort of this higher standard of defamation. Now, another thing is if it's just a person on the street. Well, that person, obviously, I have to take more care. But someone who is in the public sphere, who gets talked about, who may be important for debate questions, the government doesn't want, or the courts don't want to place such a heavy burden on us to have to constantly verify facts. So that's why, unless it's done with this malice, the court basically washes its hands of imposing any liability. Okay? Any questions about that? Yes. Sure.
See, in India, we have defamation is a recognized offense, right?
Yeah.
So it doesn't come within the purview of the Human Rights Court. So what about USA? Do you have defamation as a recognized offense?
It is a recognized, not as a criminal offense.
It now under human rights?
Because it links to freedom of expression. In other words, from a U.S. point of view, defamation or a potential defamation of a famous person, unless it's done with malice, violates freedom of expression. Do you see what I mean by that? In other words, it's a more expansive idea of freedom of expression. Now, this is not everywhere. Certainly in the European context, they don't read into it this malice prerequisite.
So in USA, it will be tried by Human Rights Court.
Well, there's no Human Rights Court. There's no Human Rights Court in the U.S.
Whichever place where human rights officers are.
The courts, the regular courts.
Right. So, but in India, it's not being part of Human Rights Court.
Okay.
That's what I want.
Yeah. So it could be. So in the U.S., if let's say I was arrested for making a statement, Donald Trump, his hair is fake. I don't know, just let's say I say that, right? Let's say I were to say.
Is it?
No, he says it's not. And he was on a television show and he let someone pull on it. So no one can accuse me of this being fake. No. So in that case, for example, imagine I get arrested, or he couldn't arrest me because it's not criminal. Imagine I get sued for it. So in that case, my imagine that the lawsuit goes forward, or imagine I were to get arrested. Imagine it was criminalized, right? In that case, my argument would be a human rights question. It would be freedom of expression. It would be based on the First Amendment of the U.S. Constitution, which affords me freedom of expression. Because the way that they deal with this question of defamation here is really from a freedom of expression point of view. This idea that if we don't impute malice, then your freedom to express yourself about these issues is limited. So that's why. So we see it from a freedom of expression point of view. Okay. Any questions? No? Okay. Attendance time then, yeah? Okay. Okay. I'll leave. Okay. Okay, so up until now, we talked about freedom of expression. We could go into it in a lot more detail, but for the sake of moving on, we're going to move on. But if people are interested, you have some more case law here that you can read through, some more cases from Europe, some more cases from the United States, and you're certainly free to look at it. Yes?
How do cases go to
of the UN? Yeah, I mean, technically though, they can ask for. They generally don't ask for that you exhaust right because it's not a court, right? I mean, it's a committee, so you can file complaints directly. There are certain countries that, well, you have to, if your country has signed a protocol, then you can go directly to it. Which a good number of countries have signed. You don't have to cross those into those domestic remedies.
And
Good question, yeah. She asked an interesting question. Whether the standard, if we look at the general comments of freedom of expression from the International Covenant on Civil and Political Rights, the standards are much more similar to Europe and to the rest of the world than to the United States. Yeah, good question. However, what we're going to see now with freedom of religion, they're more similar to America, to the United States. Okay? All right. So let's take a look at something. So if we look at Article 10 under the European Convention on Human Rights, we have freedom of expression. If we look at Article 9, we have freedom of religion, right? Everyone has the right to freedom of thought, conscience, religion. The right includes freedom to change his or her religion or belief in freedom, either alone or in community with others, in public or private, to manifest his religion or belief in worship, teaching, and practice. Yeah? So everyone has the right to change religions and to manifest it publicly. Let's compare that to here. Two things that stand out about the U.S. Constitution, right? In First Amendment, we deal with expression and religion in the same article. Everyone see that? Whereas under the EU Convention, they're dealt with separately, right? They're dealt with as Article 9 and Article 10. Now, in practice, in the jurisprudence of the European Court, people claim for both 9 and 10. But here, this was clearly done purposely as a way of sort of solidifying this idea that religion and expression go hand in hand. Everyone follow that? Now, take note about two things. When we talk about freedom of religion, and this differs from the European Convention, we have Congress shall make no law, number 1, respecting an establishment of religion or prohibiting the free exercise thereof. So under the U.S. Constitution, there are two components to freedom of expression, to religion, freedom of religion. The first component is what we call the free exercise clause. That is, everyone has the right to free exercise. The second is what we call the establishment clause. That is, that government cannot establish a religion. Okay? Everyone follow that? Why do you think, again, there's this separation. It's written as negative, right? The government shall not establish a religion. The government shall not limit your free exercise. Historically, what is the root? What is the link between this, do you think, and some historical basis?
Yeah, because if the government cannot establish a religion, the government will remain religious, or government will remain secular, as we call it.
Absolutely, but how is that a manifestation of some sort of historical question?
So that there could be some kind of supremacy of a government.
Okay, but why did people escape? The early settlers in the United States, why did they leave England? To escape religious persecution.
Yeah,
right?
Because of that, the control of absolute control of church and all that.
Exactly, the Church of England, right? Sorry?
Renaissance period.
Sorry? Renaissance?
Before that, when the church was having control of the state and they were persecuting everyone who were not doing.
Yeah. Although they came a bit later. Which? Okay.
Protestants and Catholics.
Yeah. So people escaped the church. People were fleeing. The Puritans, for example. Have people heard of the Puritans? Right? Those that practice, and I'm not an expert in questions of religion, but they were escaping persecution by the Church of England. Yeah? They were looking to be able to freely exercise their religion and to avoid a state-imposed establishment of religion. So our early founding principles, our early founding experience in the United States was one very much connected to this idea of delinking ourselves from any sort of religion imposed or forced on us by the state. Yeah? And as such, our Constitution is written in such a way that it is negative, right? That it is about this idea that I can practice as I want, that the church cannot, that the state cannot in any way create or establish a religion, either establish it in the sense of calling the U.S. a Christian country, or establish it even in more subtle ways, which we'll talk about. Okay, everyone clear on that? Okay. Now, why might in the European Constitution, why might it not talk about establishment? It doesn't in the European Convention. It doesn't talk about establishment. In other words, it just talks about that everyone can freely exercise, but it doesn't talk about establishment.
this is a European convention. You have to understand the whole of Europe. The basis comes from Britain. So you have this. You have this control of church and all that.
Yeah.
It's all there.
The religion was what governed society for hundreds of years. Spain is historically a Catholic country. Portugal, Italy, right? Those are.
You cannot do away with that.
Exactly. The history of Europe is religion, right? So the convention doesn't explicitly outlaw any sort of prohibition of establishment. Okay? Is that clear? Okay. So we have a case here called the Church of Lukumi Babalu. Yeah? Anyone read that? The Church of Lukumi Babalu is a case where in Florida the government seeks, let me just, page 276. So in Florida, they establish a law, which in a city of Florida called the city of Hialeah, they establish a law which says that it is prohibited to sacrifice animals. Everyone follow that? Unless, of course, it's for food purposes. Now, in the city of Hialeah, there is a religion which tends to oftentimes sacrifice called Santeria. Have people heard of that? It is, I think it's a Caribbean, it comes from the Caribbean originally, and one of the things they do is sacrifice animals. Okay? So the law, they create a blanket law, which doesn't specifically say this group or that group, it just says that. If we read the law, it says, again, it prohibits, it has with animal cruelty, and it says, you can't unnecessarily kill, right? Unless, again, it's for food purposes. So the question then becomes here, if they're going to limit the free exercise, because this Santeria, they're the ones, this church, they bring a lawsuit against the city of Hialeah, no? So the question then is, if the government is going to defend its right to infringe, does it have to defend based on a content neutral or a content-based level of scrutiny? Huh?
See, when the law says whoever unnecessarily kills or
it's a general prohibition.
Yeah.
So what do people say?
Yeah, it is content.
Content neutral. What does the court say? The Supreme Court. Content-based. Why would it be content-based?
This practice was unique only to this particular sex.
So they begin to look through all of the legislative history, right? And they begin to find that speeches were made against Santeria religion, that clearly the legislative intent, right? They look at the intent of it was, even though it doesn't say it, because they know that if it says it, it'll be invalidated, the legislative intent was to target the Santeria religion, right? They didn't want them slaughtering animals. They didn't like them. There was this strange Caribbean religion, and so they made a law that, although on its face looks uniform, in practice we know that it is actually the legislative intent was to target this religion. Everyone clear on that? So the way that they determined, again, the legislative intent was by going through the legislative record, looking at speeches of city councilmen, looking at things that were written, and they say, look, clearly here, the purpose was to discriminate, yeah? Okay, so if it is based on a compelling government interest, what might the interest be? Okay, one could be protecting animals, but they also kill it for food, right? So that, what else do they say? Why else do they say is why they limit it?
They have put it here, public morale, peace, safety, state's commitment to prohibit such practices and all these justifications.
Yeah, I think the most obvious is the idea of public health, right? They're saying, look, we can't have people slaughtering animals on the streets, right? In public. Even in parts of New York City, there are santeria, and once in a while you find like a chicken head, on the ground or something. And so that is that a compelling reason that you don't want livestock and stuff slaughtered anywhere on the street? Is that compelling? Yeah, that's compelling. Absolutely. I mean, I think. Do you say no?
No.
Oh, okay. Yeah, it is compelling. The court says, yeah. I mean, that is certainly a compelling reason. So the next thing is it narrowly tailored and the least restrictive approach possible? And what does the court here say? No. What would be a least restrictive approach?
To set in disciplines where to do it and when to.
Precisely. Yeah. Say, okay, you can't do it on a public street, but you could do it in this condition. Maybe we have to regulate it to make sure that when you throw out the chicken heads, you have to put in a special bag, so that way the dogs don't get into it and suddenly disease spreads, right? So precisely. So that's what they say. So they say this is a question it's a free exercise question based on the principle that this is a content-based restriction. And once we know it's a content-based restriction, we need to give it the highest level of scrutiny if we, the court, are going to allow any sort of infringement on this right. Everyone follow that? And then, as they say, regulates expression or, compelling government interest. It's legitimate. You can't have spread of disease, going back to like 1500 in England, right, where the plague starts spreading around. Obviously, they don't want the plague, or not plague, but they don't want disease obviously spreading. So that in itself, the court, I think, recognizes as being compelling. But it's not the least restrictive approach possible, and a far more restrictive approach, they say, would be, for instance, to legislate on questions of health, to create designated areas where they can practice it, provide standards of best practice or practice, and that, the court says, is a way that they can avoid having to do it. Yeah, everyone follow that?
There's a talking about content-based acts, but dealing with the things of time, place, and money restrictions. Why is that?
No, it's not dealing though. So if it had been just really a general thing, then you would impose a content neutral restriction, and you would have the government would have a lesser burden to meet. So in other words, if it were really content neutral, then the only thing they would have to prove is really that there was an important reason, and that this perpetuates it. Do you understand? So in other words, so compelling reason adds on an additional step, right? Compelling reason asks not just whether it's compelling and it's interconnected, but is it the least restrictive means possible? Do you understand that? So had it been content neutral, they probably could have overcome that. I mean, in other words, if it had been just content neutral, all they would need to demonstrate was that it was important and that this public health is related to the prohibition. So what I mean by that is that it's more likely that the court would have allowed them to prohibit it. But because the church of Lukamemi was able to prove that it was content-based, it's much harder for the government to prohibit that practice. Does that make sense? Is that clear?
Yes.
So that's the benefit. So if you are the plaintiff in this case, you want to try and prove that this is content-based, because if the other side is able to demonstrate that it's content neutral, then it's easier for them the government to be able to demonstrate their right to infringe on your right. Is that clear? Clear? Okay. So then I want to look at another case, which is the dog brew case. What page? 307? Okay, so this is a case that generated quite a lot of attention. Some of you may have heard about it. This is a Dogru versus France, the European Court of Human Rights. Let's actually just first go to this. Okay, so everybody has the right to manifest one's religion, but but, there are limitations, right? Again, limitations have to be prescribed by law, necessary in a democratic society, and again, based on a necessary in a democratic society. Legitimate aim has to be public safety, protection of public order, health, morals, protections of the rights of others, right? Very similar, slightly different, but very similar to the issue of freedom of expression. You have the right to freedom of expression, but freedom of religion, but there are clearly enumerated restrictions, right? And if you're going to violate it, it has to be prescribed by law, necessary in a democratic society. Same thing, legitimate aim and proportionality or margin of appreciation. So this case here, Doggeroo, France. Anyone know the facts? Anyone? Okay, so this is a case where a girl in the French school, in a school, a public school in France, she comes in wearing a headscarf, and the government, the school seeks to expel her, right, to prohibit the wearing of a, I think it's called a hijab, no? Is what is the hijab, yeah? And it's based on a directorate or on a directive from the government, which says, again, these are the internal school. It's from the Council of State. Let me just see that she is breaching her duty. That particularly in physical education class, she has to take it off. They say that the applicant's attitude about taking it off created an atmosphere of tension within the school. And the actual, let me just see if I can find the law. It says that it sounds content neutral, right? It basically, it doesn't target the headscarf, but it targets the displaying of any religious material. Yep. And it says, all pupils are required to dress directly and decently and in accordance with the rules. Discrete signs manifesting personal beliefs, such as religious convictions, shall be accepted in the establishment, but conspicuous signs which are in themselves of proselytizing or discriminatory effect shall be prohibited, right? So, you can wear your cross under your shirt, but no hijab, right? So, what do you think the reason for the point of view of the school is? What would be their reason? What do people think?
But they want to create a class, an atmosphere where students can just be students, irrespective of what religion they practice.
Okay. So if we look there, right, we have this idea of morals and the protections of the rights of others, right? That's what they're protecting. They're saying that coming in with a hijab, that it may be imposing, it may make others feel uncomfortable, right? That students in class feel proselytized, right? That's the argument of the state. That sitting in a classroom with someone wearing a hijab, for young kids it may influence them, and so on. There's also other arguments that have come in this case and in other cases, because there have been attempts to prohibit the full veil. That it also is a question of safety, that women can hide bruises and so on. Right? That's the argument of the state. So that is the legitimate aim that they're seeking to protect. Right? This idea of health, morals, and protection of the rights of others. That is the right of me not to be proselytized. Right? So the question is then, does it fall within the margin of appreciation of the state? What does the state say in terms of its margin of appreciation? Anyone remember? What France says is that they are historically a secular society. That secularism has been one of the, and there's actually a French word for it, which I'm forgetting now.
Laicity.
Sorry?
Laicity is the French word for the French secularism.
Yeah, but there's another word. Is it that word? Or is it? No, wait, there's, hold on one second. Let me just see if I can pull it up. What did I do? One second. Well, I don't find that, but anyway, maybe you're right. And so what they say is that we are a secular society. Historically, we're secular. Our history is based on secularism. We're not a country that has adhered to any sort of religious principles, and therefore that is within our margin of appreciation to prohibit this law, the hijab. Everyone understand that? Let me just pull out for you some specific word.
When we take a view of secularism, then in that concept comes that Sarv Dharm Sarvabha, like all religions are equal. And when you are taking as a whole that there should be a one single religion or something like that, then how can you oppose the other?
Yeah. I mean, that is the sort of hypocrisy, of it. This idea that by trying to create secularism, you end up opposing, right? I mean, I fully agree with you. I just want to find one. Hold on. The court says that in a democratic society in which several religions coexist, this is on page 315, within one and the same population, it may be necessary to place restrictions on this freedom in order to reconcile the interest of the various groups and ensure that everyone's beliefs are respected. It is frequently emphasized the state's role as the neutral and impartial organizer of the exercise of various religions, faiths, and beliefs, it says. It goes on to say, hold on, let me just, hold on. It's always, when you're teaching case law, there's always, you always lose things. The court also notes that this may not be compatible with the principle of secularism in schools, right? In that connection, the court refers to its earlier judgments in which it held that it was for national authorities in the exercise of the margin of appreciation to take care to ensure, this is paragraph 71, in keeping with the principle of respect for pluralism and the freedoms of others, the manifestation by pupils of their religions did not take on the nature of an ostentatious act that would constitute a source of pressure and exclusion, right? So essentially what they're saying is freedom and the rights of others is the legitimate aim, and it's within the margin of appreciation of France, based on its history of secularism, to impose this restriction. And with that, the court agreed with the courts of France. The court of Europe agreed with the court of France, in that the prohibition was within the restrictions. Let me ask you this. If we were, everyone understand? Anyone confused about it? Did I go too quickly? No? Let me ask you this. If we were to apply the jurisprudence from the United States, thinking about the Lukamami case, would we here use content-based or content-neutral? Content-based? Why? None of it. Is this content-based or is this content-neutral? The law is content-neutral on its face. What about, though, if we were... You think content-neutral?
Yes.
Okay, but what if I tell you this? Most of the students, first of all, you're allowed to have religious symbols, but they have to be tucked in. So, that means a cross. Where does a cross go? Oftentimes on your neck. Can that be tucked in quite easily? Yes. Most of the Jewish people who wear yarmulkes go to private schools in France. This doesn't affect them. This only affects public schools. So, who is left, really? Muslims. Yeah, precisely. So, in my argument, and I think this is the human rights, the United Nations has said the same, is that a freedom of religion, according to the general comments on freedom of religion, include the right to manifest one's religion in public. And that includes a school setting. So the UN has been quite quick to criticize this judgment, but France has not paid attention to it. They've criticized it in its UPR review and in its review of civil and political rights, but France has sort of just bucked the criticism. Whereas in the case of freedom of expression, the United States is quite radical. In this case, I think we could argue that the United States does a much better job. It's much more aligned with the general comments of the United Nations on freedom of religion. And France, on the other hand, is probably in violation of UN norms.
So the complaint was not, the complaint was just overlooked by court.
Was what?
the complaint in this case, the one that we are studying now, this Wbnujs case, the complaint was not, the complainant wasn't heard, sort of. Ultimately, he wasn't granted relief.
No.
So the right to wear headscarf was not granted by court.
No, no. The European Court of Human Rights has said that that based on the margin of appreciation and based on the legitimate aim, that in French public schools there is a prohibition against it. And in public, in a number of countries, the court has allowed the prohibition of the full veil. Yeah. Yeah. Based on the grounds of more health and safety of women. And public safety as well. Now that's been the grounds on which it's been based. Now, if we were to apply a content-based restriction here, which I would argue, if this case came in front of the United States, it would be a content-based restriction because, again, the ones that are being targeted are clearly, it's sort of not too dissimilar. A few years ago in Switzerland, there was a law, I think they passed it, that limited the height of buildings in certain cities, or maybe it was just in one city. Maybe it was in. What was the only building that was actually meeting? That was going over that height requirement or that height maximum?
A church or a mosque.
A mosque. Yeah. Not a church, but a mosque. Yeah, precisely. Similar idea here. Even though the law in Geneva, or wherever it was, in Bern maybe it was just, it didn't specifically say mosques. Nevertheless, the only buildings that were rising to that level, or the few, were mosques. Now, similar idea here. The only individuals, or not the only, but the majority of those were actually openly manifesting their religion with something that was, they say, more ostentatious than just tucking a cross or a Jewish star into your shirt, were Muslims. And so, again, if we were to apply that, then, whether it be to the question of in schools or in public, the United States courts would undoubtedly agree with the complainants that this was a violation of their free exercise. I'll just give you an example. So what the French have said is, apart from secularism, that it's intimidating to people to see people in the street with a full veil, that it hides the scars of women, the abuse. It also is a public safety issue because you have to identify yourself. I always remember I was going through the airport in New York City. A woman in front of me, she was fully veiled. She went through. They took her to the side. They said, "We need to see your ID." A woman took her to an area. She picked up her veil. Everything was fine. My bag goes through. It starts ringing. Blah. He said, "Oh, you have something in your bag? We need to." I said, "What?" No, I'm sorry. I had a little thing of peanut butter with me. They said, "No, sorry, can't take the peanut butter." And for me, that always said that ultimately, the French say, "No, it's impossible to regulate society when there are people." And what the U.S. approach says is, no, there's always ways we can do it. When you take a driver's license, perhaps if you enter a bank, you could maybe be asked by a woman to pick it up just to see that it's really a woman under there. I mean, there are things you can do, because if we apply this idea that, again, it has to be the least restrictive means possible, the French interpretation, or the European interpretation fails, right? Because there are always ways of accommodating, or in this case, in least restrictive means. As I said, in an airport, asking people to pick it up. When you're taking a photo ID, asking people to show their faces. In schools, for example, in schools, I think the U.S. court would laugh at this idea that somehow sitting next to someone who wears a headscarf is proselytizing. I think, if anything, the U.S. would say it's a beautiful thing to sit in the classroom and have people, of different faiths sitting and discussing these questions, right? Everyone know what I mean? I think the U.S. would see it as, this is a diversity that, maybe now with Donald Trump less, but I think they would say this is the diversity that makes America great, right? Whereas France clearly has demonstrated that it's an Islamophobia, it's a xenophobia. They hide it in this idea of health and safety, and the court, I think, here makes a huge mistake in not inquiring more. If the court had pushed it further, if they had done what they had done in the Lukamumi case, or the Lakamumi, or the Hubabu, whatever it's, I always forget the name, if they had looked at the legislative intent much deeper, I am convinced they would have found that this is a violation of the freedom of religion of Muslims. But again, it demonstrates that I think in many respects the European court is weaker in upholding basic fundamental rights.
Content neutral laws, does it also have to be the least restrictive?
No, it really doesn't. It just has to be substantially related to an end goal. No, it doesn't have to be the least restrictive. Sometimes they, in their jurisprudence, they're not always perfectly consistent, the court, in how they apply stricter. So they may say that it should be least restrictive, but generally speaking, no, it doesn't have to be the least restrictive. It just has to be an important government interest, and then substantially related to the end goal. Okay, everyone see that? Any questions about that? What about here? Actually, there was an interesting case recently in New York City where Sikhs they wanted to be police officers, in New York City, and it's a requirement as a Sikh, or maybe were they just on? No, I think it was just that you have to wear a certain hat. So, no, for a police officer. And what they said, what the New York City Police Department said was, you can't wear a hat over your turban. So if you don't take off your turban, then you can't be a police officer. So it went to the New York courts, and how do you think they ruled? That's how they ruled. They said, and also beards as well. Yeah. They said no. They said you can make a police hat that has a because you have to be on your hat. I guess you have to have this thing, and it has to be this color. It has to be with their uniform. And they said the New York City Police Department said no. Sorry, you have to physically meet the same requirements as everyone else. And they sought to block Sikhs from becoming police officers on the basis that they that it wasn't compatible, and based on a free exercise argument, although it didn't go to the U.S. Supreme Court, it went to it was the federal court or the city courts. But regardless, they said no. Again, this is clearly it's content-based, right? This is a content-based restriction, and is this the least restrictive means possible? And the answer is no, it's not. I mean, just prohibiting someone from becoming a police officer just because they want to wear their turban, no. Make a New York City Police Department turban, throw on a badge, and that's it. And that's what they did. So again, had this been in the French, I think it's likely they would have sided with the police department, frankly. And the European court perhaps as well. They would have found, well, based on the health and safety, you need police officers who are in full uniform, and so on, right? But no, because of this compelling reason, this idea that it has to be the least restrictive means possible, fortunately, the courts ruled that it is compatible. I mean, it's ridiculous to say it's not compatible. But anyway. Okay, good. Questions? Preguntas, in English, as we say in Spanish. Yes.
How does the US government differentiate between mass shooting and terrorist attacks?
That's a loaded question. You'd have to look at the I mean, I don't want to go into detail because it doesn't really have that much to do with this class. But I'd have to look at the exact legislation also to tell you. I don't know the exact wording of it. But I think one of the big criticisms, and perhaps rightly so, is that terrorist attacks happen when they're carried out by Muslims. Murders happen when they're carried out.
That's not the right way of putting it.
That's not me. That's the way that the government deals with it. I don't agree. But that is how. But that is the truth. There have been very few in the United States.
Yeah, the last Vegas shooting it was.
I mean, in most cases, shootings that happen in the United States, the vast majority of them, mass shootings, happened by white males. The last one in Las Vegas, there were 57 people who were killed, and yet they don't call it a terrorist attack. I'd have to look at the exact legislation. However, when an attack is carried out by a Muslim, they call it a terrorist attack. And this is, I think, again, without getting into debate here, this is it's discriminatory. Exactly. I mean, it's bias. No, it's a bias. And again, I have to look at the exact wording of a terrorist attack. But I have no doubt that most of those big mass shootings that take place could probably qualify as a terrorist attack as well. But that is an unfortunate double standard. I mean, even look at Donald Trump when he tweets or things. I mean, suddenly, if it's very sad about mass shooting, when it's a Muslim, he always says, terrorist attack again, we need to safeguard our borders. No, I mean, that's just racism. You know, it's Islamophobia, it's racism, and that's the way that it oftentimes plays out in our society. And that's just, I don't know if I can take any more chai, but thank you. I'm gonna when I go back to Spain, I'm gonna go into like withdrawal. And when someone uses drugs and then suddenly they stop using drugs, that's what's gonna happen.
You can do some chai.
Yeah, I'm gonna have to do something. Otherwise, I'm gonna start to act crazy. But yeah. I mean, that's just a double standard that we have in the United States. That's unfair, and it's prejudice. I mean, that's what it is. So yeah. Okay, but if you want, we can look at the legislation together to see what fits into it. But I do think that that's an unfortunate aspect of American society, is that there is, like in many parts of the world, a real Islamophobia, xenophobia, and when it's a Muslim doing it, it's a terrorist attack, and when it's a white male doing it, it's just a shooting. And those are different standards, and I think it's wrongly applied. Okay? Other questions? Sorry? I agree with you that it's wrong, but it's not my opinion. No? Huh?
I've already condoned that.
Okay. Any other questions? Yeah.
In regard of this case, versus margin.
I'm sorry?
This case.
Yeah.
Sir, can the Muslim girls who's against his her favor,
yeah,
the judgment was passed, can she approach to International Court of Justice?
No. I think what they did was they filed a complaint with the United Nations. And the United Nations agreed with them and filed a formal complaint with the government.
It's a matter of human rights.
It's a human rights violation. I mean, if we compare it to the general comments of the.
ICJ doesn't deal with particular cases of individuals.
Sorry.
ICJ doesn't deal with particular individuals.
No, what is state?
Yeah, because it's state.
File a case before the ICJ.
Yeah, only state.
Not ICJ.
Yeah,
I'm talking about the United. Are you talking about ICJ?
Yeah.
No, ICJ no. ICJ is between states. No, this was the United Nations Commission.
State can be litigated.
Yeah. No, you said. I'm sorry. I heard you wrong. No. What I'm talking about is the United Nations, the Human Rights Committee that monitors the implementation of the two committees that monitor the implementation of freedom of religion. A complaint was filed, and the UN High Commissioner for Human Rights said that France was in violation of freedom of expression, but France has said that they believe what they did was right, and that was it. So I think it's a violation of freedom of expression, and the United Nations I think also thinks so, but France disagrees, and the European courts disagree.
So what about KL versus Peru?
What about what?
KL versus Peru, a case a judgment given by ICJ.
I don't.
The individuals
abortion rights. It's about abortion rights.
I'd have to look at it. I don't know.
KL versus Peru.
I don't know. I'd have to look at it. Yeah. Hold on. Was there another question in the back? Did you have a question?
Yeah. The content-based and content-neutral. That's strict scrutiny. There's intermediate scrutiny. The company interest is there. The important interest you have mentioned, but important interest, time-based and manner in regard to content-neutral you have mentioned.
Yeah.
But in both the cases, Dobru and other Sikh cases, you have mentioned about the content-based. I don't know the classification with regard to this actually content-based and content-neutral.
In Europe, you're saying?
Yeah.
No, Europe.
In US only you have mentioned this one.
Yeah.
In both the cases, you are contact with the US court. If it is there, then it will be a content-based like that.
Right.
But I feel there is a content-neutral.
Why?
There is no compelling interest on the part of the state to restrict that particular one. There is
Well,
no strict scrutiny there.
Well, I would argue the opposite. I think that the real intention in this case, in the Dogru case, was to target Muslims.
It's a time-based manner you have mentioned, that intermediate scrutiny only. This is the important interest, but there is no compelling interest for the state to restrict the particular right. Is there any compelling interest?
Any what interest?
Compelling interest.
A compelling interest in the case of strict scrutiny.
Yeah, Dogru case.
But the Dogru case is in Europe, so there's no strict scrutiny.
Yeah, you related with the US also. If it is in US means that it will take.
Then I think it would be strict scrutiny. I mean, because I think what they're doing is they're specifically targeting
Actually, how they are classifying with regard to content-based and content-neutral. That's the thing.
Right. But what I'm saying is, if content on its face, this is content neutral, right? If you look at the law, it says all religious symbols. Yeah. So it doesn't say that it's specifically targeting the Muslim faith, but it's similar to the Lukamemi case, right? In the Lukamemi case, the law says all sacrificing of animals. But when you look at the real intention of it, it's specifically to target the Santeria faith. And I'm saying, if we apply that jurisprudence here, I think if we look at the legislative intent of this law in France, the real target there is the Muslim faith. And that's why I would argue that it's a content-based and not a content-neutral.
And there are no restrictions only in the place, foods only, not in all places. Even with regard to Muslims,
well,
only in foods, not in all places.
Well, now there's another case where they prohibited the wearing of full veils. And that, I believe now in France, that's prohibited.
Yeah.
In many societies, I think Belgium too, if I'm not mistaken, as well. You have to show at least your face.
So I want to ask this question.
Yeah.
It can be in dotted please. It can be both content based and then content neutral.
Okay.
If we see the content neutral side, so they are pointing out the Muslim religion. So that will go to the Muslim side. Yeah, we see the content content based. So we see that it is similar to the legitimate claim. We see that the compelling government interest, and it is similar to the legitimate claim.
Yeah, legitimate aim, yeah.
Yeah, it is only for the school.
Yeah.
What the argument has put by the government in this case, that that wearing headscarf is a sign of religious affiliation and was compatible to the proper conduct of physical education and sports classes.
Yeah.
She was lacking the physical presence in the class because she was wearing the scarf.
Right.
So this is similar to that too. It can be both content based and content based.
Yeah, although the court has to determine a standard, right? So it would be up to the plaintiff, if this were in the United States, to make an argument that it's content-based. So if I were the girl here, her lawyer, I would want to make the argument that it's content-based, because then the government has to meet a higher standard, right? Whereas the government would say, no, this is totally neutral. This applies to any religion. If you're wearing a yarmulke, if you're wearing a turban, they would say it applies across the board, right? But as the plaintiff's lawyer, you would want to look for evidence, right? Legislative intent, speeches, for example. You'd want to look at actually how many students are Sikh in the system. Not that many. How many are Jewish? Well, the majority go to the private system. You see what I mean? So it would be up to the plaintiff. If this were in the United States, in your arguments, you would want to make an argument that this was, if you were the plaintiff, that this was content-based. And the defense would want to make the argument, no, this is content-neutral. Does that, I don't know if that answers your question, or?
Adam,
yeah.
There is an apparent and contradiction between the French stand and the international covenants. Okay? So how do we address that?
The difference.
Yeah. Not only difference, it's a contradiction, sort of.
Yeah.
As we are arguing this whole thing, what is coming up with the whole idea of in the committees of the human rights covenants that we are having, international ones. This would never be the view of an international human rights convention, because this is not what it aspires to be, to discriminate. This is the apparent discrimination, and almost all of us agree to it.
Yeah.
So how do we address this contradiction? When we were on the first day, if you remember, we were discussing how do the Indian courts address this contradiction. So we have had cases where the Supreme Court said we have to interpret the national law, the domestic law, in harmony with the international covenants when it comes to human rights. So is there not any such thing in France, or is there not any such way out where we can, harmonize the two, or the contradiction we let it strive and we let it stay?
I mean, really there's not. I mean, that's that's the problem here, is that the European Court is the highest court with adjudicative powers, on the question of freedom of religion in Europe, right? So once they've ruled against the petitioner here, there's really not much that can be done. What did happen was that there was an individual complaint, I believe, filed with the UN committees, right? And it's come up in their review process. But this highlights, at the end of the day, the problem, between human rights and state sovereignty. That at the end of the day, the United Nations really can't do much. Now, what could happen at some point is that a case like this is brought to the courts again, and you have a judge who believes that this is, and that can be overturned, right? I mean, certainly the Supreme Court, for example, of France could overturn that. You know what I mean? But that is, a question of domestic law and domestic policy and interpretation. So the United Nations can put pressure through the UPR, through the committee reviews, They can cite them. But at the end of the day, if France says no, I mean, they're not going to send in peacekeepers, they're not going to send in a military, they're not going to place an embargo on France or sanction them, they're not going to go to the ICC, so there's really not that much that can be done, and that's just the sad part of human rights. Okay? But what you need are good judges, like yourself, to reinterpret the law and to say this is a violation. I mean, through strategic litigation, if that exists, someone could bring a case, right? I mean, you can certainly bring the case, and you hope a judge is willing to say this is illegal. But that all depends on the court system. How are we doing with time? Oh wait, we have a little more time. Okay, good. Any more questions? No. Okay, then I want to quickly run through in the remaining time. You have a question? No. Okay. 2 more cases. There's a case that we're not going to look at, which is but you should read it on your own. I think it's the Kakanakis versus Greece case. That has to do with proselytizing. Page
390.
No. 320. 319. I think I said 390. Sorry, yeah. That you can read on your own. That has to do with proselytizing, and again with this idea of free exercise. The case that I want to look at, though, is a case on page 395, which is called Lemon v. Kurtzman. 395. So this case here goes to the question of what we call establishment, right? That is, to what extent can the government establish a religion? In the U.S. context, when we talk about this idea of establishment, we're not talking so much about this question of can the government declare the U.S. a Christian nation? That we know cannot happen, right? I mean, that is clearly a violation. But most of the case law that we have on this question of establishment deals more with sort of subtle policies that seek to sort of strengthen or in some ways promote religion through state support.
State patronizing.
Exactly. Everyone understand that? So this is a case, and we've had different variations of it come up, where the state was giving money to public school teachers, 15% of their salaries, to teach a course in the private schools. Yeah. Okay. So if we look here, it paid teachers in non-public schools at which the average per pupil expenditure on secular education is below the average in public schools. So what it does is it seeks to, in the private schools, give professors an additional 15% on their salaries. Okay? Everyone understand that? So it basically was looking to subsidize teachers' pay in private schools. And in many of those schools, they were Catholic schools. So that's one issue that's come up. The second is that the public schools were making purchases of goods and materials from private and Catholic and religious schools. Everyone understand that? So if you look at the very beginning, it says that the Secondary Education Act of 1968 authorizes the state to purchase certain secular educational services from non-public schools, directly reimbursing those schools for teacher salaries, textbooks, and instructional material. Reimbursement is restricted to courses in specific secular subjects. The textbooks and materials must be approved by the superintendent, and no payment is to be made for any courses involving religious activity. Okay? The second one is, again, eligible to... So it has to do with basically either purchasing or providing subsidies to religious schools. Everyone understand that? Again, the law clearly says that it can't go towards the purchase of religious material. It could go towards history textbooks. It could go towards supplies. But the recipient of that money, in many of these cases, were religious schools. Everyone follow that? Yeah? Okay. So the question here is, can the court do that, right? Can the court do that? And I'm going to go through this relatively quickly, but what the court does is it specifies what's called the Lemon test. Let me just get to it. What did I do with it? Okay. The court on page 400, it tells us that in order for a state to be able to undertake some activity without it being in violation, on page 400, without it being in violation of the Establishment Clause, 3 conditions have to be met. The first is that the state must have a secular purpose, right? So the actions, when we look below the surface, they have to have some sort of secular intention. Everyone understand that? The second thing is that the principal effect, the main effect, the primary effect of that cannot be in any way to advance or inhibit religion. Everyone follow that? No? Yes? Yes. Okay, fine. I wasn't sure. Okay, good. And then, third, there cannot be excessive government entanglement. Right? There cannot be too much government entanglement, intersection, right? What does the court tell us here? What does the court tell us here? Is there too much government entanglement in this case, with the public schools subsidizing private religious schools, even if it's not only religious schools?
Yes, there is much.
Yeah, exactly. The government tells us that it does. Even if the primary effect is not to promote religion, nevertheless, the fact that it is subsidizing teachers' salaries to teach in private schools, even if they're teaching secular subjects, nevertheless, it is subsidizing a religious school. Everyone understand that? And the same thing, if it is buying textbooks and other materials from private schools, well, those private schools are making profit off of it, right? Even if, again, the primary... So it has this multi-part aim, because if we just said, is it the primary aim? The answer could be no. But even if there is, the primary aim is something else, it's just to create a better school system, nevertheless, we need to know, is there too much entanglement? And that is for the court to ultimately decide that question. But here they say that yes, that providing subsidies to religious schools is excessive entanglement. Yeah? Is that clear? Let me ask you this. What if, for example, a religious group approaches a public school and says, since you're not using the school on Saturday, we would like to use it to hold church services. Could they do that? No. That would be excessive entanglement. What about the possibility of a voucher program, where everyone in this room has $200 to spend on education per year, or per month, and you can choose where you want to? Excessive entanglement? No. What if we gave out vouchers to study at religious institutions? Yes, exactly. That would be excessive entanglement, right? So we could spend a lot of time going through the specifics of it, but what you should be aware of is this Lemon test, okay? That the principle, exactly, is not to advance or inhibit religion. That it can't be. What are they? Well, now I'm confusing myself. States must have a secular purpose. It cannot advance or inhibit religion, and there cannot be excessive entanglement. Those are the 3 elements that need to be demonstrated in order for a state to in any way interact. Okay? Now, if we think about this from a European context, I know I'm going a little bit fast. If people want to, we only have about 5 minutes. If people want to deal with it a little more tomorrow, we can at the beginning of class. But from a European context, we have what's called the Lautzi versus Italy case. And the question there was, can a public school hang a cross in its classroom? Yeah, public classroom, but they want to hang a cross. Yeah? Can they do it? The European Court says yes. Yes. Why do you think they say that? Based on the... Huh?
Majority of people studying over
It starts with an M, ends with origin of appreciation. Margin of appreciation. Exactly, exactly. Because of the margin of appreciation. What would be the margin of appreciation, and what would be taken into account? Sorry? Italy is a historically... Yeah, that it's based on the history. It's based on the fact that Italy is a historically Catholic country. Let me ask you this: in my children go to public school in Madrid. They have a class which we can exempt them from, but they have a class that's called Catholicism. Catholicism, Christianity. No, in New York, could New York City public schools offer a class that was called Catholicism? No, probably not. I mean, unless it was about, if there was a class called the history of Catholicism, could they do that? Yeah, they could. They could. But what?
The class is not, that's not mandatory. I mean, they can offer it in Islamic studies.
Okay, let me ask you this. The person in my child's school who teaches the class is paid by the church. Does that change things?
Yeah, that does.
What if the New York Archdiocese, no, the New York Catholic Church, wanted to teach a course on Catholicism in the New York public schools? No. But in Spain, they can. So we asked the teachers, what is this course about? And it's just general history. We exempted our child from it. But when I got his report card, it always tells you what the objective of the class is. And it said the objective of this class, he didn't get a grade for it because we exempted him from it. The objective of this class is that your child understands the value of Jesus Christ in his life. I said, okay, that is indoctrination. No, that's not so neutral or objective. But why do you think that for example, if I were to challenge this in Spain up to the European Court, why do you think they would allow this class to take place in the Spanish context? Huh?
It's optional, and the majority of the population
is Catholic. Yeah, it's still about 98% Catholic. Yeah, and historical reasons, exactly. It is a historically Catholic country, dating back to the 15th, 14th, 13th. It's always been a Catholic country, right? So the argument there, and I think that would probably be a winning argument, is that based on the margin of appreciation, the court would allow this to take place. Now, certainly, as I said, in New York City or in the United States, you could offer a class called the History of Religion, or the History of Catholicism, or the History of Judaism or Islam. That would be fine. But the question is, who's teaching it, and what really is the objective? And what you can see from this class is that, this is my 6-year-old son taking it, no? That the objective went beyond just the history or some sort of objective overview of it, no? And but in our constitution in Spain, it actually specifies that Spain agrees to cooperate with the Catholic Church. So it's not a Catholic country, but in the constitution it says that the government will cooperate with the Catholic Church. That obviously in the United States would never be allowed, any sort of, but nevertheless it is. Now, we have had issues, actually maybe I'll leave it because, maybe I'll end here. Well, I'll just say this, and something to think about. I'll leave you off with a problem. What about, for example, in a part of Texas some years ago, the Rotary Club. Have you heard of the Rotary Club? An organization. I don't know what it is. What kind of organization? The Rotary does charity work and so on. I think it's a non-religious organization, if I'm not mistaken, right? They erected in a public place, a public square, a Bible. No, it was a statue of the 10 Commandments. Or no, was it? No, let me double check. It was either the 10 Commandments or the Bible. The question is a non-religious organization. It's a secular organization. Is there some argument that could be made that might justify putting it there? Or what about the fact that, let me ask you this, actually a better question. On the US dollar, right, we have What does it say on the back of the US dollar?
In God we trust.
In God we trust. On the back of the US dollar. How? What about when I have to swear? I pledge allegiance, right? Oops, that's like the bell. I have to take an oath.
Today I am on time.
I take an oath. But anyway, just think about it. How? We'll start class with this. But on the US dollar, how can I get away with? How can not me, the government, get away with putting "In God we trust"? Right? Clearly, there seems to be some sort of religious connotation there. Not everyone believes in God. Is there an establishment question there? Think about how, clearly, it can be done because it's been going on for some time. How might, if you were the lawyer for the government, how might you be able to argue that "In God we trust" doesn't violate the Lemon clause, the Lemon test? Okay? All right. That's where we'll leave it. We'll start off with that question tomorrow. If I forget, just remind me. And I wish you all a good night. Okay? See you tomorrow.